Good afternoon, everyone, and thank you for joining us today for what will be a lively and engaging debate on a technology-enabled justice delivery system for India. The subject embraces a number of critical and nuanced issues such as digitization of court records, online and virtual courts, court management, transcription, live streaming, and a gamut of issues. But what I would like to focus on today is the development of technology, the infrastructure, and above all, the skills that would be suited to Indian conditions so as to make justice accessible and affordable to all. We have before us a distinguished panel led by no other than the formidable Mr. Justice Lokur, a former judge of our Supreme Court. Justice Lokur needs no introduction. He's been an outspoken and an iconic senior member of our judiciary. He is presently an ad hoc judge of the Supreme Court of Fiji. And amongst his many accomplishments, and one in particular which is of relevance to our discussion today, is that he headed the task force entrusted with the project of digitization of the Indian judiciary. So in a sense, there can be no one better placed than Justice Lokur to share his experiences and insights as to what we're about to discuss. Madhavi, as many of you would know, Madhavi Divan, is a designated senior counsel practicing in the Supreme Court. Madhavi gave up a thriving private practice on being appointed as the additional Solicitor General. She represents government in several sensitive and important cases in the Supreme Court. Madhavi's contribution to this debate is critical given that government is the largest litigant and a key stakeholder in the administration of justice. Gautam is a senior partner at the international law firm of Reed Smith based in London and heads up the India practice group at the firm. He has over 25 years of experience of high-value commercial litigation and international arbitration. Gautam has been actively engaged over the years with the Indian legal industry, including many contentious and precedent-setting matters. The comparative international perspective he brings to bear on this topic will be invaluable. With the niceties out of the way, I turn to matters at hand. Many of us practitioners before the lockdown had no idea of what a virtual court was. Our experience was restricted to the odd occasion of cross-examining perhaps a foreign witness by video conferencing. The vast majority of Indian practitioners have never conducted a hearing before a virtual court or arbitral tribunal. The enforced lockdown and the work from home model has forced us to confront a new reality, a reality that I fear will be here to stay with us probably for the foreseeable future. And the Indian judiciary must be complimented for very quickly adopting technology, albeit for urgent hearings during these troubled and uncertain times. But these initiatives, though welcome, are yet to be institutionalized, and certainly institutionalized sustainably. There is now an urgent need to embed technology in the functioning of the judiciary, given the prospect of an extended lockdown or the risk of periodic lockdowns or even changes in social behavior or norms that may ensue. The present crisis has driven home vividly the need for having virtual courts and have illustrated that a court is not just a physical venue with a canteen and corridors and courtrooms, but is an essential public service that cannot be quarantined. The themes and conversations we want to explore today range far and wide. For instance, despite the potentially transformative nature of ODR, the question as to India's readiness to adopt digitalization of its judicial services must be answered. How computer literate is our population? Will the extension of digitalization ironically increase the digital divide and result in a reduced access to justice? What are the challenges to digitalization? The technological, the attitudinal changes, dealing with the inevitable pushback from certain segments of the bar to these changes, the resistance to live streaming. Indeed, I ask myself the question, how many lawyers and judges and their court staff are using computers and technology in their day-to-day working? And a more fundamental question arises, which is video conferencing actually a medium that can be extended to courts, to subordinate courts across India, or is it an elitist medium which will have limited applicability to a handful of courts in the metros like Delhi and Bombay. So all this and more will be pondered over. And with this in view, I turn directly to Justice Lokur. So you have been in many ways at the helm of the e-courts initiative, which was initiated by the Supreme Court. Can you tell us what exactly is meant by the expression digitalization? Because it's an expression that is being bandied around by many of us, and certainly for somebody like myself included, and I consider myself in the camp of the uninitiated. What does it envisage? What was its coverage? What have we achieved? And what was the attitude of your colleagues and that of government?
Okay, thank you, Zarir. It's a pleasure being here and being able to discuss some of these issues which are bothering, I think, all of us. You know, whether we are judges, retired judges, lawyers, there are no retired lawyers, and litigants. You know, the e-courts project was conceptualized by Justice Lahoti when he was the Chief Justice of India. And the first phase of that was actually devoted to providing hardware, you know, to the judges. Many people at that point of time felt that, you know, if you use a computer and something goes wrong, you know, the computer is going to bite you, you know, or whatever you've done is just going to vanish. So the idea was to get over that fear of using computers. Of course, software development was being done. Justice Bharucha was in charge of that. Then later on in 2012, when I was appointed to the Supreme Court, I was asked to look into the e-courts project. And that's when phase 2 started actually. The idea was, you see, judges had been given computers, courts had been given computers, right? But the software development was a problem in the sense that one particular high court was developing its own software, another one was developing its own software. And it was being done only for the high courts, whereas the majority of the litigation, as we all know, is actually in the district courts. You know, so the benefit of computerization was not trickling down to the district courts where the problem actually existed, and where it concerned, you know, millions and millions of litigants. So the phase 2 was a bit of a shift, you know, from hardware to you know, software development. Now, one of the problems at that point of time, and that was, I think, probably the first couple of decisions that was taken by the E-Committee, was that what is the platform that we are going to use? You know, because at that point of time, we were talking about something like 14,000 district courts. Today, we're talking about 19,000. But if you go in for, you know, proprietary software, and if you have to pay a license fee for 14,000, you know, courts, plus, you know, the other paraphernalia for the staff and so on and so forth, the license fee is going to be enormous, you know, which perhaps we would not be able to afford. So we decided to go in for free open source software. And I think that was the turning point, because we had persons with the NIC who could develop the software, and that software could then be, you know, modified, could be utilized by us, you know, with our own team, and it was installed in all the computers in the district courts. So really, the process of you know, computerizing the district courts was more or less complete. In terms of software. Of course, software development continued subsequently. We had version 1.0, 2.0, 3.0, and so on. So, you know, both the software as well as the hardware went hand in hand. Now, during that process, you know, the high courts began developing their own software, because they said that, well, one high court said, I have my own particular needs. Another one said, I have my own particular needs. You know, I can't work on a common platform and so on. And therefore, there was a bit of a problem. But I think by now, most of the high courts have accepted the platform that has been provided by NIC, although I'm not sure whether they're using it or not. But the district courts, they certainly are. So really the focus was on the litigants at the trial court level. Now, we did try things like video conferencing. We introduced the concept of video conferencing, but that was mainly for, remand proceedings in jails. So you would have a person who would, be remanded. It was more or less in the nature of a routine remand. There was some resistance to that, initially from the judges, but the government, supported it because it meant that, getting a police escort for all these people could be obviated. And the Hard Jail in Delhi was the first to actually accept this, because they found, and at that point of time, video conferencing was pretty expensive. I mean, the cameras and all that were pretty expensive. They found that if they actually invest in, video conferencing, the cost would come down dramatically. They anticipated that they would be able to recover the cost in 2 years, but actually they recovered it in 8 months. So, video conferencing in some form or the other has been in use in the trial courts. It was used in, matrimonial cases. It was used internationally. Among the first few cases that was decided internationally was a divorce by mutual consent, where the husband or the wife was in the United States. And in fact, President Abdul Kalam called the judge to try and understand how he did it. So these things are not new, but more specifically, the problem that we are facing today, you have, as I see it, 3 different kinds of courts. You have the conventional court, of course, which is what we are used to, where lawyers go and argue their cases. That's one category of courts. You have another category of courts, which, you are calling virtual court. I have a different definition of a virtual court. But you have a court where the hearing can be conducted through video conferencing, or it can be done for, an adjournment or something through a telephone call, right? I've seen a telephone call being used in the United States. So it's nevertheless a court. The judge sits in the court, he sits on the high chair, whatever it's called, and the proceedings continue. The third category, which I call a virtual court, or which we in the E-Committee used to call a virtual court, is a court where, in fact, there is no judge, So as a pilot, we had launched it in August 2018 for petty offenses, traffic offenses. Now, in Delhi, for example, day in and day out, a couple of thousand traffic offenses are committed. Traffic challans are issued. And what it means is that there are going to be 1,000 people coming every day, or maybe 2,000, whatever the number is. It's a huge, huge number. So the footfalls in the courts, would be tremendous. So how do you reduce the footfalls, so that the courts become somewhat more congenial for litigants? That's when we came out with this idea of virtual courts, where if there is a traffic offense, you can plead guilty, or you can say, I don't plead guilty, and I want a trial. Fine, that's perfectly okay. But if you plead guilty, right, we had said that you will pay the minimum fine for that offense, 200 rupees, 300 rupees, whatever the minimum fine is. You can pay that online. Right. Now, this caught on fairly successfully in Delhi, in Haryana. I think it is being used to some extent in Tamil Nadu, and perhaps in some places, probably Pune in Maharashtra. So these virtual courts, where there is no judge, because at the end of it, the judge will say, all right, so out of 1,000 cases that I've received, 50 of them have said, I don't plead guilty. So they will go to the court. 950 say we plead guilty, and this is the amount that they have paid, and the matter is closed. These kind of virtual courts can be used for petty offenses, a very large number of petty offenses where the punishment is only a fine, delayed payment of house tax, for example, or delayed payment of some other requirement. traffic offenses, of course. So that is a concept which can be developed and which will reduce the footfalls, number one. Number two, it will reduce the litigation in the courts, right? And then, so that goes out of the system. Then you have the courts that, we are concerned with today, namely through video conferencing. Now, you can't expect a change overnight. I think one of the mistakes that all of us are making is that we are expecting a change to happen overnight, a transformation to happen overnight. It can't. There are challenges, there are advantages. The bandwidth is not available. Judges are not familiar with the use of computers. Lawyers are not familiar with the use of computers. Many of them don't have access to computers. So really, we have to go about it slowly and make sure we do a good job. We must also remember, I think, and this is very, very important, we must also remember that video conferencing or these kind of remote courts cannot be a substitute for the conventional courts. They can supplement the conventional courts, but they cannot be a substitute. So I think we are just rushing into something without actually thinking about it, sitting back and thinking about it. That is something that we should do, and I think seminars like this, webinars like this, can certainly help in that direction. Yeah, thank you.
No, thank you, sir. That's interesting as to your definition of a virtual court, which basically means the concept of adjudication as we understand it is very different. But one of the follow-on questions that arises is two things. One is, why can't we have a standard protocol cut across all courts, number one? And number two, why can't we even have standardized paper filings? And I think that's probably, from what I understand, one of the greatest hurdles to digitization of old records. Because of you need two things. You need standardized paper sizes, and you also need the proper labeling and what is called as the taxonomy, without which digitization is impossible. Did the e-courts committee look into this aspect? Because I believe this has been one of the main stumbling blocks for digitalization in our judicial system.
Yes. Now, you see, like I said, the video conferencing in the district courts was limited, right? Mainly for remands and matrimonial cases, right? And occasionally in Punjab, Haryana, I mean, not occasionally, but quite frequently, recording the evidence of doctors from the PGI. Now, a formal protocol was not developed. That was part of a process reengineering exercise. The process reengineering exercise was a massive exercise where, the entire civil court manual, the criminal court manual, the whole thing had to be rewritten. Because many of these civil code manuals or criminal code manuals were, pre-independence, and between then and now there have been a lot of changes. For example, 1 rupee. Today you don't get 1 rupee, but if you want to file a wakalatnama or a vakil patra, you have to pay a court fee of 2 rupees 65 paisa. Where are you going to get 2 rupees 65 paisa? So the whole thing was to update it, and in the process of updating it, also bringing in this new, computerization, making the rules, compatible with the use of computers and so on. That exercise, unfortunately, could not. I tried for about 4 years. The E-committee tried for about 4 years. It didn't work out, but I think that is a very, very crucial thing. That's the first part of your question about a standard protocol. And we need a standard protocol. I mean, you must have read that in Rajasthan High Court, some lawyer appeared in a vest. Why? Because there's no protocol which says that you can't appear in a vest. So yeah, it needs to be worked out, certainly. The second part of your question about e-filing, yes, we have developed an e-filing software which is available for the district courts, which we said is also available for the high courts. I don't think any of the high courts have adopted it, but it will just require, some modification. Instead of district court A, it will be high court A, things like that. instead of, and civil writ petitions or criminal writ petitions, which you don't have in the district courts. So these kind of changes can be made. I mean, they're cosmetic. But the e-filing software is available. It is not being used. One of the reasons why it is not being used is that the lawyers are not comfortable with it. Although we have a manual, we have prepared training videos that are all available on the eCourts website. Lawyers are not comfortable with it. Judges are, of course, not comfortable with it. And litigants, of course, have their own problems. So the infrastructure actually is ready. The only thing is that how do you actually put that infrastructure to use? I mean, all this is available, but I think there has to be a collective effort, on the part of everybody, right down from the district court level up to the high court level, to say that, listen, we are going to change, and this COVID thing has forced us to change. So let's look at the change and let's see how we can do something about it. We use the technique of pilot projects, which I think should be utilized. Have a pilot project, you're bound to learn mistakes. You can't be 100% perfect on the first attempt. And keep, making those changes, keep making those modifications, improvements, and so on and so forth. So you have CIS 3.0, you come out with CIS 4.0. 3.1 we came out with, 3.2 we came out with, well, maybe 3.5 or 4.0, why not? So yes, it is possible, but there has to be a will to bring about this change. Thank you.
Thank you. That's interesting to know, and hopefully the impetus for this will be the lockdown and perhaps an extended lockdown or periodic lockdowns, or even changes in social behavior and norms which may ensue in a post-COVID world, which would force people to adopt this technology. I mean, part of it, as I see it, is that there's been very little awareness about this technology, and whilst it, as you say, it exists, I don't think many practitioners or even judges have been utilizing it. Which brings me to you, Madhavi. Let me ask you, you're the law officer's perspective on this. How committed is government to supporting e-justice, allocating sufficient resources? Has any thought been given to training of lawyers, judges? How ready are the government departments that you are being instructed by to adopt technology in litigation?
See, first of all, I think we've got to understand that when you ask about government, I'll say this, that in the last few years, our India's index, I mean the ranking on the index for ease of doing business has gone up substantially. And that's largely because of IBC and single window clearances. But as far as enforcement of contracts goes, we are still very, very behind. So I think government, as any government, would be very, very keen to speed up the process. And so I don't see why government would cooperate in any measure which improves the efficiency of the court system. But on the larger issue, Zarir, I would agree with Justice Lokur on his point that technology can supplement the system, it can improve efficiency, but it cannot supplant it. I think that's important because, because we are in this very, very unusual crisis, and hopefully this will never happen again. We are forced to think about this, and yes, push has come to shove. Currently, we are, there's no choice but to use virtual courts, otherwise the entire system would come to a grinding halt. But I think it's important to remember that technology is a means to an end and not an end in itself, because there's a lot of euphoria and enthusiasm about virtual courts. Now, I would say, I mean, my essential experience is in the Supreme Court, though I would say that, given that we are a very, very vast country with huge, I mean, a very diverse hierarchy of courts, of tribunals, a lot of work is now in our tribunals. And there is a very, very, wide disparity between Of course, there are many Indias, but even between our courts and our tribunals, the nature of the work varies very widely. The profile of the lawyers who practice there varies very widely, and so does the litigating public. So there are certain areas which I think then each court and each tribunal has got to go into that exercise and try and make an assessment of what is it that we can have, technology assist us with, and what is it that simply cannot be done through virtual hearing. So, there is a lot of mopping up that can be done. I would, agree that this is very useful when it comes to traffic offenses, etc. Another area can be consumer complaints, because I think a lot of the time, litigants end up spending far more than, the loss that's actually been incurred on the litigation, which is just ridiculous. So therefore, in those kind of areas, yes, you can have some intervention. But I think generally what we've got to understand is that, well, I would say speaking for the Supreme Court where I practice, is one, I think we can do away with a lot of the paper that is generated. Some of our briefs, and I would say government briefs as well, can go up to 3 and 4 feet in height. Similarly, the courts are burdened with convenience compilations and super convenience compilations, and it goes on and on. So I think that can be certainly helped, with technology. We can eliminate that, because this in itself, paper is also spawning and perpetuating a certain, should I say, a feudalism in law practice, where we have to engage support staff, and we are all guilty of it, but there is no choice because the briefs are the way they are. It also leads to a lot of crowding in the courts, because you have huge number, bags piled up outside, people are tripping over them. It can be quite chaotic outside the court as well as inside. So I think there is a lot of, other things like, there are small applications, routine applications. There are, for example, mentionings. A lot of this can be dealt with virtually, perhaps. But I would say that coming to a lot of the real stuff, when it comes to, for example, any application or any petition which has a sort of substantial hearing involved, it may be a complex constitutional case. It may be, it may be somebody's custody battle. It may be a termination of service. It may be, somebody's bail application. And there I feel that, when it's 50-50 or touch and go, and, the opportunity to persuade the judge to, your point of view, it's going to make a difference. And that is a vital facet of the right to natural justice. So there, I think you simply cannot do away with, the real court, because ultimately physical presence in a real courtroom does make a difference. There is a tension, there is a certain impact that, an oral argument in real has, as compared to a virtual environment. And I think that we would be diluting that opportunity to be heard, that opportunity to persuade. You may win, you may lose, you may fail in your argument, but the fact that you've got that opportunity to persuade is, I think, a very important facet of natural justice. The other aspect why I feel that virtual courts cannot work in the vast majority of cases is because, there's something about the physical courtroom. When the litigant or the lawyer enters a courtroom, there is a certain aura to a courtroom, should I say. There is a certain, there's a reason the court is designed a particular way. The reason there's a demarcation between the bar and the bench, why the chairs are in a particular, elevated there, and you see the emblem right there on top. It's meant to convey something. It is, and that is the rule of law. And whatever the faults in our system, and there are many, I think the litigating public has a large, there is a very high order of public confidence. There is a lot of, judges are revered very deeply. And I think that a lot of that is taken away. It evaporates in a virtual system where you're reducing a court effectively to a virtual conference room. And that is why, as Justice Lokur said, that, a lawyer doesn't take himself or herself as seriously. You present yourself in any sort of inappropriate clothing, etc. So I think that also, I mean, it caused a lot of amusement. But the fact is that conveys something, that you're not taking the system as seriously as you should. And that is therefore, I think, I mean, to use a very tacky word, the majesty of the court. I mean, maybe there's a better expression, but I think the solemnity, the gravity is certainly lost if you just, supplant it with virtual hearing. That's not going to happen. So I think these are the two important points there, I would say. Apart from which, I think there's a lot of fixing that we can do with a little out of the box, thinking on how to manage in both the midterm as well as the long term, because I do agree that this is push has come to shove. We cannot, even in non-COVID times, we cannot afford to sustain the kind of crowds that we have in the Supreme Court. We cannot afford anymore the kind of unrealistic listings that we have. We've got to come across, there are suggestions, and we have to come up with some better solutions on that, where you have realistic listing, so that matters which are listed and very few of them are heard. And it's not, you can use official transcription. You can, there's a lot that can be done to ensure that, hearings, take place with the help of technology.
That's an interesting perspective, Madhavi. You're right. I think one of the risks or dangers of a virtual court is the lack of due process. But I think a lot of it is also, and you're right, the gravitas of a physical courtroom is lost when you're doing a virtual court.
Yeah.
It will require a shift in mindset and of practitioners, because most of us have now become so accustomed to the form of advocacy, particularly the form of Indian advocacy that we have, which is very much oral, is based on oral submissions rather than paper, that it's going to take a little bit of time for us to adjust to this. I think there are other jurisdictions, and certainly in arbitrations, where this shift has already happened. I think we're all agreed in the same breath that this is not a substitute. Virtual courts are not a substitute for physical courts, but the technology behind it can be used for certain efficiencies, such as filings, listings. There's a whole host, crowd management.
It can be used very well. Basically, it's technological housekeeping. A lot of that can be done very well with, all of these devices. But I think that we've got to also sift out what kind of applications, what kind of matters that can be dealt with virtually, which do not require any great persuasion. I mean, these are routine applications, whether you are mentionings or you have, your traffic offenses and that kind of thing. But you've got to probably go court-wise, tribunal-wise, and figure it out. That what is it that we can, have mopped up through a virtual hearing.
Yes, I think that's interesting, because I now turn to Gautam to share his experience of the functioning of regular courts in England. And as most of us know, certainly the civil justice system in England is fully functional even during the lockdown. They're conducting trials by video conferencing, very different. And as I see it, requests for adjournments also have been denied by the courts. The judges there are playing a far more proactive role. And Gautam, can you share with us your experience as to how this is being conducted in the UK? What are the best practices that perhaps can be adopted and adapted by Indian courts given local conditions? How has technology enabled the English courts to function during a lockdown?
Thank you, Zarir, and hello, everybody. Great to be here and speaking with you all. We've had a really interesting experience here due to the lockdown. The courts have been functioning essentially as normal by virtue of the technology. And as you mentioned, full trials have happened over technology. So, we've had, our firm was involved in a 5-day final hearing, which involved cross-examination of factual witnesses and expert witnesses. So the judge was sitting in the courtroom but everyone else was dialing in by video. And there are many other examples where this happens. And I've got some hearings coming up later this month that will also happen in this fashion. Now, clearly the technology is very good now. I mean, we take it for granted, but certainly it wouldn't have been like this some years ago. But the technology is there, and it means that justice can be dealt with. Now, Madhavi mentioned a very interesting point, which I think we here in England must be very mindful of, that no jurisdiction is the same. Every jurisdiction has its different tugs and pulls and challenges. Here we have the ability to utilize the technology. I think everyone has the ability to do it, but all cases are being dealt with where appropriate by technology. Adjournments are not happening. So we're having 1-hour applications dealt with by technology. We're having 5-day hearings being dealt with by technology. So there's no sort of demarcations. And I think you're right when you say that adjournment applications are not being given credence, because the system has to go on. And even after lockdown finishes here, things are not going to go back to normal just by magic. You know, by the flick of a light switch, things are not going to go back to normal. Social distancing is here to stay, and we are not going to be sitting in courtrooms or arbitration hearing rooms together anytime soon. So things have to happen now, and especially if you're a claimant, if we're representing a claimant, we want to get things moving. And now it may be a different thing if you're acting for a defendant, but if you're acting for a claimant, you want to move things on, and the judges want to deal with things. And our Lord Chief Justice and other senior judges, in giving guidance to the courts, to judges and to advisors and to clients, is very much of the case. Look, we have to get on with things because it's important. And now another important factor in this is that historically, as everyone will know, the English courts have been utilized for international transactions, even where the parties are not resident in this country. So it's very common that English law will be chosen as the governing law of a contract, even where the parties come from different countries, because English law is regarded as a very safe choice for international contracts. And so the English courts want to maintain that reputation as being the jurisdiction of choice for dealing with international disputes. So that's another big reason why people are getting on with it. And frankly, we've also learned lots of lessons from arbitration, because in arbitration, things are also moving on, and hearings are taking place remotely. And that's arguably more complicated, because you've got often tribunal members from 3 different countries. You've got lawyers from different jurisdictions, different time zones. I mean, it's one thing being in the same time zone, but it's quite another being in different time zones. And so all of these experiences mean that there's a real drive for things to happen, and the technology is available. You know, people can sit during a hearing on the technical side, and they can oversee things so that if anything does happen, they can rectify it on the spot. You can ensure that things that you can have sort of separate chat rooms where the arbitrators can talk to each other, and you know, the like. So we've learned a lot from arbitration as well in how we go about doing things. And my last point I would just make, and I think this goes to a couple of points that Justice Lokur and Madhavi mentioned. I think remote hearings mean that we have to be better advocates. And in many ways, written advocacy in advance of the oral advocacy is even more important now. Because we have a tradition here in the English system of skeleton arguments and written oral and written submissions in advance of the oral submissions. And, you know, that can fine tune a lot of things, but actually it makes the process even more important that we submit better written submissions in advance of the oral submissions, because it makes everyone more attuned to what's going on, and makes the whole process happen a lot more efficiently. So I'm mindful of time, so I will stop there. But I think we've had some interesting experiences.
Hey, that's very interesting, Gautam. And is the reason for the courts functioning in the UK due to the fact that they've had bundles filed electronically? Has that always been the case in the UK, where you don't take physical paper bundles into court anymore?
No, that's a very interesting point. That's now very important to have these e-bundles. But historically, though, we've always had hyperlinks in our documents. So when we submit written submissions, we have hyperlinks to where the exhibits appear in the files. So the judges can look and the advocates can look on the hyperlink and get the documents very quickly. Now, historically, when we had in-person hearings, we would have the old-fashioned bundles of paper in files, beautifully paginated by our teams, and most likely a fraction of that paper would be referred to in the submissions. And that's unfortunate for the environment, but that's what happened. I think e-bundles are anyway much more efficient, because you've got them in soft copy. You can deal with things a lot more, a lot faster. But actually, that's a new thing, Zarir. But hyperlinking, so having hyperlinks to exhibits and documents, is not a new thing. But that's even more important now. And I mean, I personally am a huge fan of it, even though I'm not a young man anymore. But I certainly prefer that system of doing things.
That's interesting. And just another point, Gautam, can you share your experience about telephonic hearings? Because as a means of conducting a hearing in India, particularly in courts which do not have access to a high-speed broadband connection, is it possible or indeed feasible to conduct a telephonic hearing?
Yes, it is. But again, it has to be the right sort of thing. So it wouldn't be appropriate where you have cross-examination of witnesses, for example. But it would be appropriate where you're basically doing legal argument, where you've got an interim application which will be focused in on whether this is right or this is right, or essentially to have a form, a derivative of what Madhavi was mentioning about case management. So I've got a hearing coming up in early June in the High Court in London, which is going to be a 2.5-hour hearing. That's going to be just the advocates and the judge, but it's going to be done telephonically. But that's where there are no witnesses in the sense of cross-examination, and it's basically argument. So yes, it can happen in lockdown and even after lockdown, but I think it'll be the exception rather than the rule.
Thank you. That's interesting. Justice Lokur, I'm turning back to you. It would be interesting to get your thoughts on whether in an extended period of lockdown, we can actually resume some sort of regularity in the functioning of the court, or normalcy in the functioning of the courts by video conferencing. Is it possible to extend the hearing list that we currently have to urgent or extremely urgent matters to a slimmed down list? Would that be feasible? That's my first question to you. And the second, which is a slightly more controversial and polemic one, is what according to you are the challenges or obstacles to digitalization and the adoption of technology by the Indian judiciary?
Okay. As far as your first question is concerned, maybe about listing more cases, if you go to the Supreme Court website, you will find that there's only one court that is functioning, right? So you will have 3 judges sitting, on a day-to-day basis, and they will take up about 10 or 15 cases. You may have, 1 or 2 other benches which may be constituted for the purposes of delivering judgment, Now, first of all, I don't see why it should be only one bench. We've got 34 judges. So why can't we have, say, 15 benches or 16 benches or 17 benches? Why not? I mean, that's possible. And if supposing each one of them, takes up, say, about 10 cases, you can have 150 cases being listed, right? There need not be very complicated matters in the sense of, cases that require arguments going on for an hour or so. You have short matters, for example, right? Those can be taken up. So it is possible to, vastly improve and increase the number of cases that can be listed. The problem is the bandwidth. That's not available. That's number one. Number two, I'm not sure how stable the application that they're using. They're using video, VIDYO. I don't know how stable it is. There are other problems, that lawyers face. For example, if a senior counsel wants to, consult the instructing lawyer, it's a problem. You can't just switch off and say, "Listen, I want to, find out something." So there are these, kind of problems. But yes, in terms of the number of cases, it can certainly be increased. And I don't see why that should not be possible. The challenges that the judges will face, it's not easy to sit in front of a computer for 2 hours and listen to submissions. At the end of the day, you start getting tired after half an hour, 45 minutes. Concentration may waver. It's not easy for a lawyer, to argue for 45 minutes or 1 hour or 2 hours. And if the hearing is going to go on for the whole day, it's not easy. So there are challenges, but they will have to be gradually overcome. And like Madhavi said, you can't have every case, being taken up through video conferencing. It's just not possible. So you will have to find some alternative means. I remember reading maybe today or yesterday or something, that the Supreme Court of the United States is going to have a telephone hearing, for the first time in history. So they already have audio recordings, but now they're going to have a telephone hearing. I can tell you about Fiji. The concentration is on written submissions, right? So oral submissions go on for about maybe the scheduled time is 40 minutes, but except in 2 cases that we heard, and I mean, we're not rigid about 40 minutes, you have to switch off the microphone kind of thing. In 2 cases, we did give time to the lawyers to argue for more than 40 minutes. But in a large number of them, the arguments finished in 20, 25 minutes, 30 minutes, definitely well within the 40-minute limit. So, changes will have to be brought about, both from the side of the judiciary and also from the side of the lawyers. Now, to what extent, the lawyers and the judges are in a position to bring about a change, I don't know. You see, I'll give you one example. In the Bombay Blast case, the famous one, the number of documents ran into more than 1 lakh of documents, exhibits, and all that. The whole thing was on computers, but the judges did not use the computers at all because they found it inconvenient. It helped the registry, because if a lawyer said, "Listen, I want to refer to exhibit 28," the registry guy could take out that exhibit without much of a problem because he knew where exactly it was located in his computer. So, that, and also incidentally, apart from the judges not using the computers, even the lawyers didn't use computers, although the whole, 1 lakh pages, 1 lakh plus pages were on in a soft copy. So there has to be this change that has to come out from both sides. And I like I said earlier, I don't think it can come about in a day or so. It will take a long, long time, but eventually I think changes and adjustments will have to be made if we have to, progress. Yeah.
That's interesting, sir. Your illustration of the bombast case as showing the efficiency gains that can be derived by the use of technology. Now, perhaps the lockdown and the work from home model will provide us the impetus for a more quicker adaptation and adoption of these methods of work. But do you think we need to go back to the grassroots where law college curriculums need to be rejigged? Do you think we need to have a much more aggressive training program for lawyers and judges, and the judges effectively taking the lead and being more proactive in forcing lawyers to adopt technology?
Yes, I think you're right. They should introduce this in law colleges, but I don't think judges can force lawyers to do something. That is just completely out of the question. I think the lawyers will have to, do something about it. I just want to mention, the chairman of the Bar Council of India recently wrote a letter.
Correct.
That 90% of the lawyers are not technologically savvy, right? He may be right, but he also said that the E-Committee of the Supreme Court did not consult lawyers. Now, in January 2014, when we had a meeting and when we accepted phase 2 of the program, 2014 or 15, whatever. On my insistence, and I was supported by Mr. Ghulam Vahanvati, who was then the Attorney General, that the lawyers should be involved. We said that the Bar Council of India should nominate the president, the chairman, or should nominate somebody to attend all the meetings of the Bar Council so that, the lawyers are familiar with this. So for every meeting that we had, we invited, we sent a letter to the chairman of the Bar Council, but we did not get a response from anybody for even one of those letters. I mean, there was not even an acknowledgement, that we received your letter and, sorry, nobody's going to come. So really the change has to come from amongst the lawyers, because that's a much larger community. 18 lakhs, I think, is what the chairman said. So for the 18 lakh people to, have a change in mindset is the challenge. Maybe you can have 700 judges, maybe 19,000 judges, change their mindset, judicial academy, and so on. But really, I think the change has to come from, the change in the form of acceptance has to come from the lawyers. Unless that happens, we are going to be stuck where we are.
That's interesting. Madhavi, what are your views on the Supreme Court Bar Association resolution? I can understand the Bar Council of India, which they make a valid point by saying that 90% of the lawyers in the country do not have the technical hardware or indeed the skill sets to be able to navigate online dispute resolution. But surely in the Supreme Court, where you have fairly high value litigation, by and large it's an urban area, Delhi is urbanized, people would have access to technology, one would have thought. Do you think that this is really people feeling, or the lower segments of the bar perceiving this to be a threat, technology to being a threat?
Well, I think we shouldn't confuse use of technology with the idea of virtual hearings. What I understood of the SCBA resolution was that they said that, look, we can do this for now because there is no choice, but we're not going to have this supplanting the oral hearing, in a real courtroom. So I think that is a valid thing to say. And I personally, I also feel, for the reasons I've already given you, that a virtual court cannot supplant a real hearing in many, many situations. But I think what we need to do, and I think Justice Lokur is very right when he says that it needs cooperation from the bar and the bench, and the bar also needs to cooperate in ensuring a more efficient system, because what we do see in the Supreme Court is that the judges have to work extraordinarily hard. Whether it's just the volume of work or it's the sheer variety, the range of matters that come. And likewise, I would like to believe that the bar also works very hard. But somehow, all this hard work, unfortunately, doesn't get translated into the kind of efficiency I think that the system and we as stakeholders in the system deserve. And I think, therefore, the problem is systemic. Now, just importing and educating ourselves in technology is not going to be enough. We need to change the systems, and perhaps we need to think a little bit out of the box. This is a good opportunity. So we need to think midterm. I mean, when there is a full lockdown, there's not much you can do. You have to survive on whatever you can in virtual hearings. I agree with Justice Lokur. Perhaps we can do much more maybe by consent. If advocates want their matters to be listed and they feel that they would not lose out in that sense in a virtual hearing, I think by consent, their matters should be heard. We also need to think about the midterm and the long term. The midterm may, for example, if there's a partial lockdown or there are norms on social distancing, etc. What can you do? And I say this not as a law officer, I say this as an ordinary practitioner. What I would say is, for example, if you were to take out identify 3 rooms in the Supreme Court building, 3 rooms only, which are very, very distanced, and given the sheer width of the Supreme Court, that's very easy to do. You identify 3 rooms very spread out there. Identify maybe a couple of rooms in the building across the road, which is very, very wide, and it's a very brand new building. It's a beautifully constructed building. So we could have makeshift courtrooms there if necessary. This is a suggestion only as a practitioner. Now, what you can do, you can work in shifts. If you need to ensure that you cannot have crowds, and we cannot, even I believe that in the long term, we cannot sustain crowds even in very normal situations. But for the time being where we just cannot afford it, what we could have is courts sitting in different shifts, maybe 2 shifts, maybe 3 shifts. Even in the summer months, you can sit early in the morning, you can sit in the afternoon, and you can sit late in the evening. And different sets, as Justice Lokur rightly said, we have so many judges. It's almost full capacity right now, full strength. So maybe in benches of 2s, you can have you can go up to 3 shifts if you like, and if your staff is willing, basic support staff is willing to come, and lawyers can choose their timing. So that can be done midterm to ensure that there is no unnecessary crowding, and you list very, very minimal. You may, even in the midterm, you may choose to list with consent. For example, the 101 series of hearings, say the leave granted matters, where you say in 15 days, you give notice to the advocates on record. You say that, look, would you like, your matter is likely to be listed. You take a fixed date, a fixed item number, which is then non-negotiable. Once the AORs agree to it, it becomes non-negotiable. You put in, and for the long term, we can have these listed even 3 months in advance. Because what I find that happens in the Supreme Court sometimes, and this has happened in constitution bench cases also, that Saturday afternoon, the list comes and suddenly, advocates on record are scrambling around for counsel because their matters, constitution bench matters, are listed on a Tuesday. That gives you, most of us are working for Monday matters, and there's no time to prepare for Tuesday. So therefore, I think if you have those kind of matters where you 3 months advance notice, these are not new matters, you give a fixed date, you give then it becomes non-negotiable because you've had that much notice. If you need a change for any reason, you apply well in advance. There should be a pre-estimate of arguments which is taken from counsel well in advance. As Gautam says, exchange oral arguments well in advance. Once your pre-estimate of arguing time comes in, then the clock is ticking, and you have given that pre-estimate yourself. So, and that is something that, can be sorted out virtually, how much time, who is to be given, etc. Once you have that before you, then you do not, that is non-negotiable. You can supplement it, your oral arguments later in you can amend your written arguments later, all that can be done. But this ensures that, those matters are going to go on. So you don't have these crazily long lists of matters where, people are hanging around because they don't know whether their matter is going to reach or not, whether the board is going to collapse or not. That's a standard question. Is the board going to collapse? Why should the board collapse? And sometimes, psychologically, when I would imagine that when when judges see so many people in court, you may not be in the frame of mind to, you know, sit with one matter and be able to sort of, you know, you have the right sort of frame of mind to be able to hear a matter. So, and what about the, you know, the time of the advocates who are hanging around over there? What about, you know, is there no value to their time? Is there no value to the litigant's time who is unsure, will the matter reach? He's going to incur a fee. So, you know, all this can be sorted out with technology, but let's not confuse virtual hearing for the use of technology.
Interesting. Madhavi, do you think a hybrid system could be developed which would address all your concerns, where some proceedings are conducted online and others in a physical court?
So I think
even within a matter, you could have some stages of the matter of a case being decided online and some in a physical courtroom.
Yes,
and that's where technology can be helpful.
Yes, so as I said, routine applications which don't require any great persuasive skills. You can have mentionings. So I mean, you know, the matters that you hang around before the registrar and there are long queues in the corridor now, maybe that can be handled in a different way. But of course, you need to take the SCBA and you need to take the Advocates on Record Association and understand their problems before, you know, one puts any system in place. But I think, yes, this exchange of written argument and then with the right to supplement it immediately after the hearing is over. And you see, that's where when you have a pre-estimate of arguing time and you have official transcription, this would be very, very useful because it in the long term, I believe that it would discipline both the bar and the bench, because the counsel knows I've got a set amount of time. I cannot beat about the bush. You cannot be verbose. You have to get to the point quickly. And the judge will also be sensitive to the fact that, look, I'm not going to make more interruptions than necessary because, you know, he or she is functioning on, I mean, the clock is ticking. So I think in the long term, it will become a good sort of record and a good discipline on both the bar and the bench. So I feel that's something that's more important, frankly, than live streaming.
That's interesting. I was going to take you to live streaming, given that you were involved in the Swapnil Tripathi case, right? In the Supreme Court.
I later appeared for the Supreme Court on the issue of implementation, which is still pending. Yeah.
It'd be interesting to get your views, Madhavi. Is the perception is that there's a resistance or a reluctance of live streaming of proceedings, and why is that?
Look, there is a judgment now, and therefore, you know, it will be implemented. But I have my own, I mean, as a practitioner, I would say that I do have, you know, some reservations, because if we are going to pick, and the petition was really picking the high profile cases, it wasn't the regular, you know, the ordinary cases that were going to be live streamed. And yes, I would say that it's an important facet of open justice, and for interns and students to be able to, you know, to get a real sense of how things work. But I think there's a downside too, which is that, you know, you don't want your court to be, you don't want your judges thinking about, you know, you want the matter to be decided for what it is about. And you don't want to give an opportunity to people to play to the gallery. I mean, you know, from the bar, that can happen. So I think that I personally feel that, of course, it's a judgment of the court, and it, you know, live streaming can have very, very, particularly in times of, say, COVID, where you know, you can have if you can't allow litigants to enter the court, you can certainly have them watch the proceedings be live streamed. But I personally feel that before that, we must have you know, transcription. That would be very useful, very, very useful.
That's interesting. Gautam, just before I wrap up, can you tell us what your experience in the UK has been of live streaming? Has there been any criticisms about it in its workings?
Yeah, no, it's an interesting point. You know, we here, because of access to justice rules, all of our hearings in any event are always open to the public, unless they're in camera. So there may be some matters where it's a confidential matter, or where, for example, it's for an injunction and it's an ex parte application, etc. But so most of our hearings are open to the public. And interestingly, in one of the, I mentioned when I was making my comments earlier about the 5-day trial which our firm was involved in, which happened by virtual hearing. The hearing was relayed live on YouTube. So everyone was given notice that it would be broadcast live on YouTube. And believe it or not, many people who weren't involved in the case actually took time out and logged on to YouTube and watched it. So these things are important, I feel, for access to justice. I guess on Madhavi's point, I can't resist the slightly coming back on the point, which I agree with actually, that in some cases, some advocates may try to play to the gallery. Inevitably, that there are going to be some swashbucklers, some flamboyant characters who try to make the most of it, but you can never rule that out. But I think most of us, I would say, and I humbly include myself within that, I think we would all try to play by the rules and not be too swashbuckling when we went about our submissions. I think we would, going back to one of the points made by Madhavi, I think it is right that one gets a first impression, especially when one appears in front of Justice Lokur. You know, we have to be very mindful of etiquette and good manners and sensible, but we shouldn't lose the fact that it's a real hearing and it's happening remotely. But we have to be respectful, courteous, of course, be very passionate in our arguments, but be respectful.
Well, thank you very much. I think we've exhausted our time, and thank you all to the participants. Thank you to IDEX. We've got a number of questions that have come in. I'm afraid we won't have enough time to deal with it, but there's just one question which I think is common. There have been a few which I want to share, get everyone's views, Justice Lokur and Madhavi's, before we log out, and that is, given that we are going to be, at least for the foreseeable future, in some form of lockdown or social distancing, how can we get the courts working again? What is achievable under current conditions? Because I think we clearly have to move beyond the urgent matter listings that we are currently experiencing. Madhavi, you go first.
Okay, I think I did make some indication of that. I would say that maybe we understand that there are a lot of AORs also who would feel disadvantaged, not only because they are maybe, technologically disadvantaged, but, they may not feel comfortable given the nature of their matter to, to have it heard in a virtual hearing. So I think that a counsel and advocates on record have to have a choice in the matter. And if this is, I'm talking about the immediate term before we, the lockdown is lifted. So if I think by consent, if AORs are willing to go on with their matters, perhaps those should be listed. That can be certainly considered, because as Justice Lokur rightly said, we are running in the full strength of judges, but perhaps more could be heard, more matters could be disposed of. Also fresh matters, I think, which were filed probably a couple of months ago and which may not have been heard even at the notice stage, that could be considered again. There may be counsel who feel that, no, I don't want to take a chance. It's a 50-50 touch and go, and I don't want to take a chance. You give people that choice. So
according to you, it should be by consent? It
should be by consent, yes. If you want your matters listed, I don't see why they shouldn't be listed. If the counsel, AOR and litigant are willing to take, that chance in a virtual situation, I don't see why not.
Justice Lokur, do you think the court should, the judge should be more proactive? Because in any dispute, there's always one party who will have a vested interest in delay. If we leave it entirely to the litigants, to the consent of litigants, there's bound to be some amount of injustice. Can that be addressed by a more proactive judge?
Yes, I think the judges will have to be more proactive, number one. Number two, the lawyers will have to be more proactive. You know, why should a lawyer play along with a litigant who wants to delay a case, right? Now, I'll tell you about one case that we had in Fiji. I was not on the bench, but the other judges told me. The advocate on record had got the date wrong or the time wrong. There was some mistake, and she wasn't ready with the case. So she asked for an adjournment, and the judges said, "All right, we'll take it up tomorrow." Why tomorrow? Because the lawyer for the other side had come in from New Zealand, right? So they said that we'll take it up tomorrow. The lawyer has come in from New Zealand. He was paid for 1 day. Brief was for 1 day. Now he has got to spend 2 days. He has to cancel his ticket to go to New Zealand. He has to stay 1 day extra in Fiji, right? So all these expenses you have to incur in terms of cost. And we'll take it up tomorrow. Otherwise, we're going to go ahead with it today. And she said, all right, I'll make the payment. And she did make the payment. So, there was this understanding. It's not that the, advocate, began screaming and shouting or crying, or saying, why all this, I made a mistake and this, that, and the other. So the lawyers knew that, that if you ask for an adjournment, you pay for it, So I think it has to be both between the bench and the bar. I mean, it can't be that, the judges have to be proactive, but the lawyers can take it easy. But the lawyers have to be proactive and the judges have to take it easy. It can't be like that. I think both have to be proactive. One fact that I want to mention, Chief Justice Bobde mentioned in an interview recently, I think it was in the Hindu, that on an average, 205 cases are filed in a day in the Supreme Court on a normal day. That's the average. Now, if we continue with this, 15 days, of course, now far lesser number of cases are being filed. But if we don't increase the number of cases being listed and disposed of, you're going to have a huge problem. If you're going to dispose of 15 cases in a day, as against 200 being filed, you're going to drown in that deluge.
That's interesting. So your experience, the experience that was narrated to you in Fiji, I wonder whether we'll be in India be able to implement something like this, because certainly one point of view is that a litigant would be justified in acting in his self-interest if that meant delaying a matter. Certainly that's the view. Our system is very tolerant to that sort of abuse. So the question that does arise is how do we address this, given that you're going to be faced with a deluge of cases and the backlog is just going to keep mounting. These are there are no easy answers. I think the takeaway from this is that we've made a beginning with the use of technology, and I hope this accelerates given our predicament. Hopefully, both the bar and the bench will partner together to try and address some of these concerns. We should get people like Daksh and some of the other organizations, and indeed the advocates on record and the bar associations to provide their input, because it has to be a dialogue and a consultative process if we are going to ensure that this technology can be adopted and justice made accessible to all during the lockdown or extended lockdown. But thank you all very, very much for this. Thank you to the organizers. Thank you to all the participants.
Thank you.
This has been a great pleasure and a privilege to have all of you on this panel and share your views. Thank you all.
Thank you. Thank you, Zarir. Thank you.
Bye-bye.